This is The Briefing, a podcast presented by Mussio Goodman Law Firm.
Today the topic is how can I disinherit family members? And we're here with Wes Mussio, managing partner at Mussio Goodman Law Firm.
Thank you.
So Wes, I want to avoid a wills variation claim. How can I do that when I have family members I don't want to receive anything?
So earlier in the other podcast, I mentioned that pretty well it's very difficult, if next to impossible, to disinherit your spouse or your children. There's rare circumstances where you can. So what I tell clients, and this is a big business for lawyers, is you can plan your affairs before you pass away to basically make it impossible to do anything in terms of burying the will, because there isn't anything going through the will or through probate that can be disputed. So what happens is there's a number of different aspects, but you can put your house in joint tenancy name with what's called a deed of gift in favor of that individual. You can get all your bank accounts, if it's an RRSP or an investment account or a RIF or whatnot, you can put the named beneficiary on there as being the individual you want to have the assets. And then also you can set up an alter ego trust even, which will further solidify the fact that all your assets are moving to other people upon your death, but not through probate or not through the will. And so even if the will disinherits somebody, there's no fight because there's no assets that are going through the probate situation.
Why does this work?
Well, it works because the only thing that can be disputed is what is actually going through probate. Now, probate's an interesting thing because people think, if somebody dies, we have to basically, put all the money through this probate and then goes to the beneficiaries. That's not true at all. So the only time you have to move money through probate is if it's in the name of the deceased, the dead person, and you need to put it into the name of the executor who then distributes it to the beneficiary. So the whole purpose of doing this estate planning is to avoid any need for that. So if the asset transfers to the individual you want it to be transferred at the time of death, then it no longer becomes part of the estate or the probate or the will.
Is there a downside to this type of estate planning?
Oh, definitely. Now, the one thing is, if you don't do it right, you can get a big legal challenge. That's a big downside. So when I say do it right, if you're going to take that approach, you should be doing what's called a deed of gift, or a declaration from the will maker that says, listen, I'm making this asset, I'm giving it to so-and-so, and it's a gift. And if you do that, then it's pretty hard to overturn that. But the other problem is if you start doing things like an alter ego trust or whatnot, then there's all kinds of tax implications, because what happens is there's a deemed disposition of your asset at the time you transfer it to the trust. And so guess what? The government comes looking for the taxes, and they might want property purchase taxes, they might want speculation and vacancy taxes, they might want capital gain taxes. So you've got to be very cautious about what you do and how you do it to avoid, significant tax implications. And so what I tell people is, hire an expert that knows what they're doing on this area. If you're going to be trying to plan to disinherit one of your family members, it can be done, but it has to be done very carefully and with precision so that they can't later dispute it in court and the tax implications aren't horrific for you, the will maker.
What is your best advice?
Well, my best advice is if you really are interested in taking about this approach, do an alter ego trust. Now, the reason why those work, and what it basically does is the settlor is going to be the will maker, and so they can keep accessing their assets until they die, and then once they die, it goes to a set of beneficiaries. And if you do that one right, then it can't be disputed, because the only way a trust is ever overturned is if all the beneficiaries, even the existing ones or future beneficiaries, all agree, yep, we're wiping out the trust, and that's the only time it can be broken. So if you take certain assets, put them into the trust, they're basically untouchable. And so you can definitely, estate plan to provide your assets to people that you truly want to have, as opposed to having a court decide by way of a wills variation that certain people deserve something that you didn't want happening. Because remember, in a will's variation claim, testamentary autonomy, which is the will maker's right to choose, it takes second fiddle to the legal and moral obligation owing to your spouse and your children. And if you have any further questions on this topic or others, feel free to reach out to me at my email, mussio@mussiogoodman.com, or give me a call at 604-336-8002.